When parents are unable to agree on issues relating to the care and well-being of their children, or a parent is concerned for their children's safety, an application can be made to the family court for assistance in settling the dispute. Once an application has been accepted, it will be given a hearing date in the Child-Related Proceedings or CRP list. The first hearing date will usually be about 6 weeks from when the application was filed, although if the matter is urgent, a request can be made for an earlier listing. At the hearing, a magistrate, with the assistance of a family consultant, will have reviewed the application and other relevant information, such as history with other courts, police and the Department of Communities, and will issue parenting orders to protect children at risk until the issues can be fully assessed or resolved. When there are unresolved issues of safety at the hearing that need to be discussed further, the magistrate may ask the family consultant to schedule a case assessment conference.
I will now make some orders for what is to occur until the next hearing, and after I have reviewed the report of the family consultant from the case assessment conference.
At this conference, which both parties must attend, you'll meet individually with the family consultant to discuss the risks, to achieve safe resolutions and try to narrow the issues in dispute. The central focus of the case assessment conference is to assess risk in relation to family violence, neglect, abuse, mental health issues, substance abuse and parenting capacity. And there are 2 overriding considerations that the court and the family consultant take into account: the benefit to a child of having a meaningful relationship with both parents, and the need to protect children from physical or psychological harm and being subjected or exposed to abuse, neglect or family violence. 2 hours are normally allocated for the case assessment conference, and it is often the first meeting between the family consultant, the parents or other parties to the application, and their lawyers if they have them. The parents will be interviewed individually with their lawyer present if they have one. The family consultant will decide who goes first on a case-by-case basis. Before the interviews commence, the parties will be informed that the process is not confidential. This means that what is discussed can be summarised in a report to the magistrate and/or discussed with the magistrate in court. In this example scenario, the father, whose former partner is trying to limit the time he spends with his children, will enter the room first with his lawyer. This interview can last for between 30 and 45 minutes, although in complex situations it can continue for as much as 90 minutes. He will be asked about his current arrangements.
We've been separated for about 3 years. I haven't seen my 2 kids for 2 months since she said I threatened her and was drinking too much.
The family consultant will explore how well he actually knows his children.
Involved in any sports yet?
Jamie's in grade 2, I think. Maybe it's 3. The younger one starts next year, maybe. She's still at home anyway. I think Jamie's doing Auskick. Maybe when he's a bit older, I'll go watch him play footy. I reckon it's all a bit pointless until they can play properly.
Making reference to the mother's application and the father's responses, questions will be asked regarding the risks created by his alcohol use, threatening behaviour, mental health issues and his relationship with the children's mother.
Explain a little bit about that to me, please.
Sure, I can get a bit noisy after a few drinks, but I've got to wind down somehow. Why should that stop me spending time with the kids? She's just got it in for me, I reckon.
The direction the conversation takes will be fluid, depending on where the father focuses, but will be managed by the family consultant to ensure they have been able to find out information across the range of issues. The level of exploration and detailing of questions will vary greatly depending on the nature of the allegations made and the level of engagement of the father. The father's lawyer's role is to assist the father or to explain things when the father is having difficulty with recall or managing his emotions. It is not the lawyer's role to speak instead of the father.
If you want to take a break now, I'll talk to Mrs. Jones.
The consultant will then commence a similar interview with the mother, essentially a mirror of the interview with the father. There are many variables as to the progress of the conference at this stage. In some cases, if it's appropriate and safe, By agreement, the family consultant may meet with the parties and lawyers together to either give feedback or to consider agreement on any issues that are negotiable at that time. At times, the father and/or the mother are brought back in for further discussion in light of the information gained from the other party's interview. This can include feedback to assess their responses, reactions and denials to each of their stories, proposals discussed with the other party for consideration, looking at short-term arrangements, exploring the possibility of agreement between the parties. Where there are negotiated outcomes, the lawyers may draft a minute of consent. It may also include an adjournment of the next court date until after some of the interim agreements have been fulfilled. Where there is no possibility of negotiation, the family consultant will provide an outline of their assessment and the recommendations they are considering making to the court, which may include referral of the parties to a suitable treatment program, recommending urine analysis or hair strand testing, seeking further information from schools, medical records, criminal proceedings, family therapy, supervision of time, trialling a spend time with the children arrangement on an interim basis, interviewing children, recommending external expert assessments, or a follow-up conference with the family consultant to review the arrangements that have been made. The conference will end when the process has reached a conclusion, a stalemate, or it has gone beyond the allocated time. Irrespective of the outcomes, at the conclusion of the conference, the family consultant will prepare a written report outlining the content of the conference and provide the court with recommendations as a result of the assessment. A copy of the report will be provided to both parties and their legal representatives, and signed orders by consent of both parties may be pronounced by the magistrate in chambers. It's important to be aware that discussions held during a case assessment conference are admissible as evidence in court, and the family consultant's report will be placed in the court file for the magistrate at the next hearing, which will have already been set for between 2 and 6 weeks after the case assessment conference.